judgment in this case will be to do that. Now, we will proceed by asking the other members of the panel the read of the judgment, and then the judgment will be read. We'll be happy to have you dismiss. Then we can put up the hand, go to other things. Those of you who are active have now become redundant. Without this judgment, like the return of Jesus did not come, life is here. The new judgment is here, 200 pages. It will be there. I think it may take us 16 hours. So can I ask Lady Justice Monica Bogeno?
Thank you, my Lord Chief Justice. And good morning, Council. This is my judgment. I have had the benefit of reading in depth in this matter. I am in complete agreement with the position of the in relation to ground 2 of this appeal. I do also abide the position of the General Court Martial established under Section 195 of the UPDF is a subordinate code of competent jurisdiction under Article 129(1)(g) of the Constitution. I note, however, respectfully adopt a slightly different approach to the scope of such offences under the UPDF Act. I therefore consider it necessary to provide my perspective to that issue within the context of the entire appeal. Elements of a right to a fair hearing, as highlighted in Article 28(1) of the Ugandan Constitution, are similarly expressed in various international forums. The party refers to the present purposes in the International Covenant on Civil and Political Rights. The United Nations Human Rights Committee. Excuse me.
the presence of UPDF.
It's not intimidation. It's not a pledge. It's not a pledge.
Davis. Abasajja bali nfunye position wali ate nawo tebaagala nkolerewo bayaba NBS ate kamera yaabwe yakusooka konvatinga yes anti gwe abanjogeza bali mu kubanjogeza. Ladies and gentlemen, subscribe. They are making a technical issues here. Some technical issues are going on. That's the legal team for this judgment today, the judgment of Mike Kabaziguruka. Good morning. You can as well tell me where you're watching from. If you are watching from heaven, now is God and Jesus. How are the angels and everything?
Hello.
Council. wetuli kanso kasoma eko kintu tusuubire ki olunaku olwaleero mu kooti eno
kufuna ensala y'omusango gwa kabaziguruka n'ekibiina kya omwami oyo yawaabira kkooti y'amateeka kkooti ya ssemateeka kiragirirwa nti kkooti ya ssemateeka n'esalawo si kituufu abantu ba bulijjo oba bayite basivilia kuwozesebwa ku kkooti y'amagye kati atomekemu n'akirira basobole kkooti era olwaleero
agenda situkaddeyo
tusuubira nti tulina obuwanguzi era tusuubira nti onaayibomaiwa kabaziguruka agenda kuwangula apiriwo eno kooti enosalewo nti abantu ba bulijjo tebalina kuwozesebwa mu kooti y'amagye kooti eno bweneesalawo ekyawukanaku ekyo tujja kwewuunya nnyo kubanga amateeka gateekasi
tweyanza nnyo honorable ate nga kanso mumulabye egendebwa kanso nalukoola tusuubire ekyo lunaku olwaleero mu kooti waneeno
twandisuubidde nti kooti eno ensukkulumu egenda kukakasa ebyo byennyini ebyazaalwa kooti etaputa ssemateeka naye abalamuzi balina ebbeetu okukola ensobi oba okutaputa mu ngeri etali eyo gyobadde osuubira naye nga ffe abaagala eddembe ly'obuntu obwenkanya enfuga ennungi okubeera mu nsi yattu twali akadde era twalisuubidde nti kooti ensukkulumu egenda kukkiriziganya n'abalamuzi aba kooti etaputa ssemateeka nga bwe bataputa nti ddala ddala omusiviriani omuntu wa bulijjo tasaanya kuvunaanibwa mu kooti z'amagye
tweyanza nnyo secretary general good morning council what should we expect tusuubire ki olwaleero waneeno
As a cost tusobola salawo so far tusuubira nti signals bijja kuba Uganda kibasinga okuwabira because olengera judgment eruddewo for a long time ate ngaekwata ku ddembe ly'omuntu martial court martial tusuubira nti neddembe okukyalina abantu ba civilians so ekyo kirabala muntu yenna alonga so I think judicial tuyambe tuliwo kirabo kisinga obukulu esobole okuwa ensala yaayo banyamazima ate nga yakwenkanya kooti zino wezisema tutulaba nsonga lwaki omuntu wamugamba nti mutwale mu kooti ye ate nga si wamagye ate nga tulina segendamiza yitwala telefoni bannayuganda abatali bamagye ate nga ne petition actually council kwageraataddeyo ofuna petition yogera kutegeeza kooti martial teekwa wansi wa sigaddala teekwa wansi wa judiciary igwa musigaigwa ddala so we think let them help us but ekisinga obukulu basalamuzi
tweyanza nnyo kansolo na lukikundu ensonga ozirabidde ddala bulungi senfuma ono mukulu wange omumanyi ono senfuma nkola naye munsabira ntwale eri eri ku TV enene. From a ministry. Okujja mu kaadi kuba like okuteeka mwene levisa
obadde okwatira okwo
mbadde muwa kaadi
obadde ogikwasa kuno
yange
kati kati jamu ogiteeke muno ebyasoso byagala
eyiya ngambye yakufomatinga akako kaba kakufomatinga salamu aleikum naye
ate n'ekirala era alirayo wanagambira
katire bugwawo Davis nayo gamba segugwawo amala dduka misingi ne mugamba segugwawo ayinawo wano emmere tegenda mmalaga bateri salamu aleikum naye kyeŋŋamba mbaze nze nkitene nebakwata ati Davis wamazeemu amaanyi wangambye omusajja agenda kuluka
bagenda kudda
ladies and gentlemen, subscribe. That is the legal team. That is the legal team. As you see it is the legal team of Mike kabaziguruka. The judgment has been brought and it has a lot of ate nkugezaako okugamba onteremuko tukwate kaadi togifomatinga nti togifomatinga with a different video signal. Akanindompe togifomatinga kuliko ebitali byange. They are walking about sound. And probably after. Probably after walking about the sound.
Hello.
Ebifaananyi byakufomatinga gakonvatinga njimanyi kamera muganda wange sagala kukolera lojuko yagambye agenda kunteera matuusa wanagera ananesala ate ayani ayombe
nyakutuga
position efuse position.
Hello.
ngenda fune
Tutale. Kugamba balaze subiriri mugwe kumpe ebifaananyi. Bijjawo
bingi wano tetuyinza biremererwa
ate na laptop.
bingi.
Kale.
Okay, we alive.
Obadde okozesa essimu ng'ate okozesa ne kamera kati nga
Nedda sokolabe navuddewo dda nze nawulidde oyo siniya waayogera junior taddamu kati ekiriwo
ogambye genda kuwaki
mpagu
ogambye tekuweki
ogenda kumpa ku
yungenda kuweera ddala oli kuki soka onyigemu okamulabe okyali kyagiranga ekyali kusikisimu ate okugamba angiriramu nagera bange ngazikulako nyero
nkwatiraako just essimu bwoti tereezeemu wano
2021, the Attorney General, Honorable Michael Kabaziguruka, Forum.
No, just say the court is constituted as before.
Much obliged. The court is constituted as before, my lord.
Please continue.
Thank you, my Lord Chief Justice. The elements of the right to a fair hearing, as highlighted in Article 28(1) of the Ugandan Constitution, are similarly expressed in various international covenants, the pertinent one for present purposes being the International Covenant on Civil and Political Rights. The United Nations Human Rights Committee has since pronounced itself on Article 14 of the ICCPR in its General Comment number 13 of 1984 and General Comment number 32 of 2007. General Comment number 13 proposes that the trial of civilians in military courts should ensue in very exceptional circumstances and in conditions that genuinely abide the dictates of Article 14 of the ICCPR. It was in January 2006 supplemented with the draft principles governing the administration of justice through military tribunals. The draft principles on military tribunals were rooted in the 1984 General Comment number 13 and must now be construed with due regard for the committee's revised position as encapsulated in the 2007 General Comment number 32. General Comment number 32 demonstrates that the Human Rights Committee does recognize the trial of civilians in military courts, albeit in exceptional circumstances and within established parameters. It calls upon state parties to guarantee the fairness, impartiality, and independence of such trials, which in any event would only be justified in exceptional circumstances and for serious and objective reasons, with appropriate regard for the suitability of civilian courts for the individuals and offences in question. That is the universally established command of Article 14 of the ICCPR. Courts martial are established by the UPDF Act by dint of Article 210 of the Constitution to preside over the service offences defined in Section 1 of the UPDF Act, which include the offences enshrined in Part 6 of that Act. The intricate nature of the service offences they preside over supports the view that the primary function of courts martial is indeed to foster the efficacy of the military in securing the country and its borders. The enforcement of discipline within its rank and file is a vital component of that objective, but is certainly not the sole function thereof. Be that as it may, the main bone of contention as far as the jurisdiction of the General Court Martial is concerned appears to be the status of that military court in the national judicial system. Black's Law Dictionary defines a competent court, which is interchangeably referred to as a court of competent jurisdiction, as I quote, a court that has power and authority to do a particular act, one recognized by law as possessing the right to adjudicate a controversy, close quote. In the matter before the court presently, the juridical competence of courts martial can be deduced from the definition of a court in Article 257(1)(d) of the Constitution as juxtaposed against Articles 123(b), 137(5), and 257(2)(a)(1) of the Constitution. I find fortitude for this view in the case of Attorney General versus Joseph Tumshave, where this court adjourned the General Court Martial to be a subordinate court. I therefore abide the position in the lead judgment that the General Court Martial is a subordinate court of judicature within the confines of Article 129(1)(d) of the Constitution. However, the respondent extends his displeasure to the legislature, faulting it for supposedly exceeding its legislative powers when it created the General Court Martial under the UPDF Act and conferred it with criminal jurisdiction, empowers Parliament to enact laws that govern the UPDF's organs and structures, as well as its discipline. Having found that the General Court Martial is indeed a subordinate court of judicature, it follows that its establishment under the UPDF Act and the delineation of its jurisdiction therein was well within the remit of Parliament. However, the scope of that jurisdiction is a matter of contention before this court. I find that the term service offense in Section 1 of the UPDF Act would encompass the offenses created under Part 6 of the UPDF Act in relation to the persons delineated under Section 1171A to F of that Act, as well as offenses under any other act that are committed by the same category of persons. Hence, the scope of service offenses in question restricts the inclusion of civil offenses to those cases where the civil offenses are committed by persons that are in active military service as delineated under Section 1171A to F of the Act and on field operations. Persons that are not in active military service but only became subject to military law by dint of subsection 117(1)(g) and H of the Act would not be tried for service offenses in the military courts. I now turn to the contentious question of the jurisdictional scope of the General Court Martial over civil offenses. I do acknowledge the position taken in Attorney General versus Joseph Tumshave that there is no provision of the Constitution that restricts Parliament from vesting a subordinate court with jurisdiction that is also within the purview of the High Court. For present purposes, however, I take the view that this lacuna should be interrogated with regard to the special character of courts martial and existing international safeguards in respect of military courts. Principle 8 of the Draft Principles of Military Tribunals considers crimes committed in the course of field operations to be sufficient justification for the trial of civil offences by military courts. Indeed, Section 198(2) of the UPDF Act does recognize the function of field courts-martial in presiding over offences committed in the course of field operations, I quote, where it is impracticable for the offender to be tried by a unit disciplinary committee or a division court-martial, close quotes. This position is reiterated in Section 177 of the Act, albeit with additional emphasis on a civil offence translating into a service offence, whether committed within or outside Uganda. I am alive to the character of courts-martial as special courts that are set up to address a specific area of the law, having a more limited jurisdiction than the courts of general jurisdiction, being faster and often not bound to follow the same procedural imperatives, and field court-martials are particularly characterized by quick processes that are not unduly bogged down by the procedural imperatives that obtain in general jurisdiction civil courts, or indeed other courts-martial, given the peculiar conditions within which they operate. Indeed, the Constitution recognizes the peculiarity of field court-martial when in Article 137(5), it exempts their processes from constitutional references. In those circumstances, closing such field courts-martial with jurisdiction over capital offences that attract a potential death sentence might appear gravely ill-advised, but for the following two critical conditions. First, to restrict field courts-martials to non-capital civil offences would be to leave capital offences that are committed in those sometimes fluid situations uncatered for and unaddressed. This indisputably would be inimical to the administration of criminal justice and an affront to the rule of law, which subjects all persons to the law. Secondly, Principle 17 of the Draft Principles on Military Tribunals is emphatic on the right of appeal from courts-martial, which by extension would include field courts-martial. Accordingly, the right of appeal from the decision of a field court-martial does provide a vital safeguard to the exigencies of their judicial processes. Its relegation to creation by subsidiary legislation is a misnomer that ought to be revisited. In the event, I would abide the proposition in Principle 8 of the Draft Principles on Military Tribunals that the circumstances under which field courts-martial operate do provide sufficient justification for their jurisdiction to try civil offences, including capital offences. Having so held, and considering that the General Court-Martial sits in appeal over decisions of field courts-martial, I would refrain from excluding civil capital offences from its jurisdiction. I now turn to the constitutionality of Section 1171G and H of the UPDF Act. The controversy as to the constitutionality of those statutory provisions has arisen in numerous cases with varying results. It now falls to this court, under the present appeal, to pronounce itself with finality on the matter. The fundamental question is whether the parameters that are encapsulated in Section 117, 1G and H amount to exceptional circumstances that would justify the trial of civilians in military courts. The law is a major component of public policy and would thus be vital public policy consideration for the justification of the trial of civilians in military courts. Indeed, I am alive to the duty placed upon Ugandan citizens under Objective 29 and Article 3(4) of the Constitution to uphold and defend the Constitution and the law. This perhaps explains why criminal law considers a person that aids or abets the commission of a crime or has a common intention with others in the commission of a crime is criminally culpable. Reading Section 1171G of the UPDF Act, together with Section 191C of the Penal Code Act, would suggest that a person that aids or abets a serving or active military person in the commission of the service offences delineated in Part 6 of the Act would be deemed to have taken part in committing the offence, be guilty of the offence if proved, and may be charged with actually committing it. In practical terms, Ayume Francis in Criminal Procedure and Law in Uganda posits that a person who aids and abets another in the commission of a crime may be joined in one charge sheet and tried together with those who actually commit the crime but the particulars of the offense must clearly indicate the role of the aider and abettor. I take the view, therefore, that criminal culpability by way of aiding and abetting the commission of a service offense is sufficient justification for the subjection of a civilian to military law. I respectfully do not abide the view that such trials should not axiomatically ensue in the civilian courts. In my view, the fact that the principal offender is a person in active military service and charged with a purely service offense warrants the recourse to military courts as opposed to civil courts for the trial of both the principal offenders and their accomplices. Furthermore, the intricate nature of service offenses encapsulated in Part 6 of the UPDF Act would be better suited for trial before military courts rather than civil courts. I would, however, abide the exemption posited in Oxford Dictionary of Law that, and I quote, when a member of the armed forces is charged with conduct committed in that is an offense under both service law and ordinary criminal law, the trial must, in certain serious cases, e.g. treason, murder, manslaughter, and rape, be held by the ordinary criminal courts and is in fact usually held by them in other cases, close quotes. I would construe this position to draw a distinction between the pure commission by a military person of a service offense on the one hand and a service offense that is also available as a civil offense. In addition, though seemingly restricted to capital offenses, I would extend it to non-capital offenses that accrue as both service offenses and civil offenses. In my view, therefore, the general rule ought to be that military service offenses are only triable in military courts and civil offenses are only triable in civil courts, save for two exceptions: the trial by field courts-martial of military persons that commit civil offenses during field operations, and the trial of service offenses by civil courts, where such offenses do also exist on the ordinary criminal law statutes. I would therefore uphold the majority in the Constitutional Court that civilians that aid and abet military persons in the commission of a service offense do by their actions subject themselves to military law under Section 117(1)(g) of the Act. Section 1171H, on the other hand, subjects to military law any person found in unlawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defense forces or other classified stores. I find no definition in the Act as would guide a reasonable member of the public as to what type of military equipment is the monopoly of the UPDF, let alone what would amount to classified stores so as to avoid the prohibited conduct. Article 2812 of the Constitution considers a criminal offense that is not adequately defined to undermine the right to a fair trial and thus prohibits convictions arising from vague and ambiguous criminal offenses. The need for a precise definition of an offense is associated with a principle of legality that translates into the constitutional principle of void for vagueness. The void for vagueness doctrine essentially requires that a penal statute define the criminal offense with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. Thus, legislative provisions that have not been defined with sufficient conciseness have invariably been adjudged to be void on account of their vagueness. On that premise, therefore, I am unable to endorse the constitutionality of Section 117(1)(h) of the Constitution. In the result, I find that service offenses as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the legislative mandate of Parliament or the objective of the UPDF under Article 210A of the Constitution. Nor in any case are they inconsistent with Articles 28(1) and 44C of the Constitution. I do additionally find that the provisions of Section 117(1)(g) of the UPDF Act do constitute exceptional circumstances under which the subjection of civilian offenders to military courts would be justified. To that extent, that statutory provision is not inconsistent with the Constitution. I, however, find Section 117(1)(h) of the Act to be void for vagueness and therefore inconsistent with Article 28(12) of the Constitution. I would accordingly resolve ground 1 of the appeal in the affirmative, but respectfully find no merit in either ground 4 of the appeal or the cross appeal. I now turn to grounds 2 and 3 of the appeal. The right to a fair trial is anchored in the principle of judicial independence, which in the Ugandan Constitution is articulated in Article 128. In the same vein, Principle 13 of the Draft Principles on Military Tribunals proposes, I quote, "The organization and operation of military courts should fully ensure the right of everyone to a competent, independent, and impartial tribunal at every stage of legal proceedings. The persons selected to perform the functions of judges in military courts must display integrity and competence and show proof of the necessary legal training and qualifications, and military judges should have a status guaranteeing their independence and impartiality, in particular vis-a-vis the military hierarchy." Close quote. The UN Human Rights Committee additionally enjoins states to take all necessary measures to ensure that such trials take place under conditions which genuinely afford the full guarantees as stipulated in Article 14. The African Commission of Human and People's Rights has similarly adopted the stance that military tribunals must be subject to the same requirements of fairness, openness, and justice, independence, and due process as any other process. Thus, in the Constitutional Rights Project versus Nigeria, it decided that a tribunal comprised of one judge and members of the armed forces could not be considered impartial because regardless of the character of the individual members of such tribunals, its composition alone creates the appearance, if not of impartiality and bias. Close quotes. The General Court Martial of Uganda was established under Section 195 of the UPDF Act. It is composed of 7 members, all of whom are appointed by the High Command for a period of 1 year, subject to reappointment by the same appointing authority. Its membership is solely comprised of military persons, with no provision whatsoever for their professional qualifications, neither are such qualifications provided for its reserve members. Therefore, although at any one time the actual members of the General Court Martial could very well possess the requisite qualifications, its de jure composition is purely restricted to qualification on the basis of military service. In Inkawa versus Turkey, the European Court of Human Rights, highlighted the specific factors that would be taken into account in determining the impartiality and independence of military judges. The court astutely identified the crux of the matter as the confidence which courts in a democratic society must inspire in the public, and above all, as far as criminal proceedings are concerned, in the accused. It further deduced the parameters that will support independence and impartiality of military judges to include the same professional training as civilian judges and the enjoyment of constitutional safeguards identical to those applicable to civilian judges. It additionally expresses concern about military judges being servicemen who still belong to the army, which in turn takes its orders from the executive. And they remain subject to military discipline, and the appointment of these officers is made by army structures for a short renewal term. That decision is most persuasive on the standard of independence and impartiality expected of military judges and military courts. In any event, the concerns expressed in it are re-echoed in Principle 13 of the Draft Principles on Military Tribunals. Paragraph 7 of that draft principle emphasizes equivalence in professional qualifications, ethical standards, and constitutional safeguards between judges in civilian courts and their counterparts in military courts as a safeguard for their independence and impartiality. In the matter before us, the respondent having pointed to review Section 195 as the legal basis for his misgivings with his trial before the General Court Martial, the evidential burden shifted to the other one to factually demonstrate the independence and impartiality of that court. Regrettably, such evidence was not forthcoming. I do not accept the appellant's proposition that military courts in Uganda are impartial and independent simply because Article 221 of the Constitution enjoins court-martial rather than a factual situation that pertains to them. Consequently, in complete agreement with the late judgment, I find that the constitution of the general court-martial does compromise its independence and impartiality as a subordinate court of unlimited jurisdiction, and is to that extent inconsistent with Article 28(1) and 44(7) of the Constitution. In the result, I will resolve ground 2 of this appeal in a negative. On the other hand, ground 3 of the appeal, under ground 3 of the appeal, the respondent's arraignment before the general court-martial is specifically challenged on account of the omission in the charge sheet to indicate his role in aiding and abetting the commission of a service offense as contemplated under section 117(1)(g of the UPDF Act. As was earlier observed here, a person that aids or abets the commission of an offense is deemed to have taken part in the commission of the offense, and if proved, will be guilty of that offense. In the instant case, an incomplete charge sheet was annexed to the affidavit in support of the petition as Annexure A. It reveals that A1 to A8, with whom the respondent was arraigned, were at the time in active military service and therefore automatically subject to military law. The respondent, on the other hand, is depicted as a civilian, a member of the 10th Parliament of the Republic of Uganda, representing the Power Division in Kampala District, and designated as a person subject to military law by virtue of section 119(1)(g), 117, that is 117, 117(1)(g) of the UPDF Act. Under count 1 of the charge sheet, the statement of offense is stated as offenses relating to security, contrary to section 131(a) of the UPDF Act, while the particulars of offense indicates that the respondent, together with 22 other named persons and others still at large, between the months of February and June 2016, in diverse places in Wakiso, Kampala, and Gweru districts, with intent to prejudice the security of the defense forces, contrived a plot to overthrow the government of Uganda by force of arms. Close quotes. Although the charge sheet referred to in section 117, I'll say that again. Although the charge sheet referred to section 117(1)(g) of the UPDF Act under the description of the respondent, it did not spell out his role in the commission of the alleged service offense. This would indeed amount to a defect. However, not every defect in a charge sheet would make it valid in law and render the ensuing proceedings a nullity. The test to be applied is what the effect of the defect is and whether if proceedings are concluded, it has occasioned a miscarriage of justice. In this case, no attempt was made to demonstrate any such miscarriage of justice. On the contrary, insofar as the charge sheet highlights the statutory provision that brings the respondent under military law, which is clear on the issue of aiding and abetting the commission of a service offense, the respondent would have been on notice of the nature of offense he was arraigned for. Furthermore, the charge sheet spells out the principal offenders by highlighting their status as persons in active military service. Moreover, borrowing from the civilian courts, under section 132 of the Magistrates' Courts Act, a court that is faced with a defective charge has a wide discretion to amend it at any stage of a trial. As a similarly subordinate court, that option of amendment of the charge would have been available to the General Court-Martial to clarify the specific role played by the respondent in the alleged offense, as well as demarcate who of the persons he was arraigned with were the principal offenders. Consequently, given the procedural reliefs available to him, I do not find the defects in the charge sheet in this case to constitute sufficient reason to declare the respondent's arraignment before the General Court-Martial a violation of the right of fair trial. However, given the then the jury composition of the General Court-Martial under section 195 of the UPDF Act, the respondent's arraignment before that military court cannot have been in accordance with the right to a fair trial before an independent, impartial, and fair court, as envisaged in Article 28(1) of the Constitution. I would accordingly resolve ground 3 of the appeal in the negative. This brings me to what would be appropriate remedies in the circumstances of this case, and whether or not they should apply retroactively. Black's Law Dictionary distinguishes true retroactivity from quasi-retroactivity. The
former consisting of the application of a new rule to matters that were completed before the law came into force, and the latter entailing the restriction of a new legal rule to matters pending completion. In Griffith versus Kentucky, the U.S. Supreme Court reiterated its view in United States versus Johnson on the need to apply a new constitutional rule to all criminal cases pending determination in order to uphold basic norms of constitutional codification. That case was cited with approval by the Constitutional Court in Madera versus Attorney General, and I still consider it to be good law. I would thus equally cite with approval the observation in Group Madera versus Attorney General that a new constitutional rule in the realm of criminal procedure be applied quasi-retroactively or restricted to cases pending final disposal to avert the dire effect on the rule of law and the administration of justice of full retroactivity. Griffith versus Kentucky additionally posits that unlike the legislature, it is not the function of the judiciary to formulate laws on a broad basis, its role being limited to the declaration of a new rule directly arising from application. This is similarly acknowledged by the Canadian Supreme Court in the case of Scapta versus Canada. That case was relied upon in Fish Eric in the article Choosing Constitutional Remedies by Fish Erickson. The choice of appropriate remedy between severance and reading in, where a statutory provision violates the Constitution, hinges on whether the nature of the constitutional inconsistency entails something improperly included or excluded from the statute. In the matter before us presently, Section 195 excludes such professional competencies in the membership of the General Court Martial as would mitigate connotations of partiality and non-independence. As such, reading those omissions into that provision might have been the more appropriate remedy, but for the fact that the deference to the competence of persons with a military background was at the time informed by the scarcity of legal professionals in the military, as well as the complexities of securing legal professions in field courts issues. This is borne out by the parliamentary debate in respect of the then Uganda People's Defense Forces Bill, as reported in the Hansard of that time. So that reading into Section 195 of the UPDF Act, the constitutional safeguards and membership as the court deems appropriate would be tantamount to usurpation of Parliament's legislative function by judicial overreach. However, the same SAFTA case proposes another constitutional remedy that gives the legislature a chance to craft its own solution. Provision for legislative reform there would, in my view, address the shortfalls of the previous legislative process and provide an opportunity for the review of the military justice law in Uganda, as has been done in other jurisdictions. This would align it with the independence and impartiality safeguards envisaged in the right to a fair trial under the Constitution. It will suffice to observe here that unlike judiciary-driven reforms that ought to be restricted to matters that were in contention between the parties, legislative reform may holistically address matters that were not necessarily an issue before this court. It might similarly approve the right to a fair trial in court issues. This would forestall avoidable litigation in respect of related matters and abide the notion of disposition. The upshot of my judgment is that this appeal partially succeeds while the cross appeal fails. I do abide declarations 1, 2, 3, and 6, orders 3 and 7, as well as the advisory orders D, E, and H as stated in the new judgment. In the result, I will set aside the judgment and orders of the Constitutional Court and substitute them with the following declarations. 1. The General Court Martial is a subordinate court of competent jurisdiction within the confines of Articles 129(1)d and 257(1)d of the Constitution, but its de jure membership under Section 195 of the UPDF Act does underline its independence and impartiality, and is to that extent inconsistent with the fundamental right to a fair trial enshrined in Article 28(1) and 44(c) of the Constitution. 2. The respondents are raising before a General Court Martial that the jury membership of which does not pass constitutional muster was a violation of his right to a fair trial, and to that extent is inconsistent with Article 28(1) and 44(c) of the Constitution. 3.
Section 117(1)H of the UPDF Act is void for vagueness and therefore inconsistent with the right to a fair trial as enshrined in Article 28(12) of the Constitution. 5. Service offences as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes
with either the objective of the UPDF Act under Article 210 or the legislative
mandate of Parliament under Articles 79, 129(3) and 210 of the Constitution, nor in any case are they inconsistent with Articles 28(1) and 44(c) of the Constitution. I shall pronounce my final order as the quasi-retrospective application of all cases pending before the General Court Martial in light with Order 2 above. I would respectfully propose the following additional advisory order for consideration. The General Court Martial be substantially composed of civilian judges who are directly appointed thereto by the Judicial Service Commission in accordance with the Constitution, as is presently done in respect of judges of the Industrial Court, and the members of the General Court Martial from within the military should be appointed in consultation with the Judicial Service Commission. I would so order.
Councillor Naka, during my time, you would have the decency of bowing to the judge. Thank you. And we have Lady Justice Catherine her judgments.
Thank you, my Lord Chief Justice. I have had the opportunity to read the draft opinion of the Honorable Justice. He ably sets out the questions for determination before us, as cited the relevant sections of the UPDF Act, Part 330, and the related constitutional provisions which are said to have been contravened. Please note that the sections of the law I will be quoting are quoted from the immediate past laws of Uganda volumes and also from the most recently published edition. So in my final judgment, you'll find two versions of laws. When I read them, I'll read the one that you probably cited during the hearing. I would allow this appeal in part. The Attorney General lodged an appeal against the decision of the Constitutional Court dated 1st July 2020. The respondent had challenged the competence of the General Court Martial to try civilians under the Uganda People's Defense Forces Act, alleging that the continuance of these trials violates constitutional provisions, including Articles 28(1), 44(c), and 210 of the Constitution of the Republic of Uganda. The Constitutional Court, being the court of first instance in constitutional matters, heard the petition and decided that the General Court Martial is a constitutionally established court set up to handle cases of military discipline for the UPDF members, but lacks jurisdiction to try civilians for offences under the Penal Code or other enactments. As a result, Sections 2, which now reads as Section 1, Sections 1191H, and Section 179 of the UPDF Act, which expands military jurisdiction of the courts martial to include civilians and classifies civil offences as service offences, were declared unconstitutional for violating fair trial guarantee and exceeding the mandate under Article 210(b) of the Constitution. Finally, the court found that the Section 119 is not unconstitutional, provided the person not otherwise subject to military law is tried as an accomplice together with a person who is subject to military law as the principal offender on the same charge sheet. I am abundantly aware of the tension that exists between ensuring unfettered military discipline and compliance with the tenets of constitutional right to a fair trial, which should be available to all human beings, including men and women who serve in the military. This entails a delicate balance on a constitutional landscape which the courts are obligated to navigate. I have, in my judgment, undertaken a synopsis of the historical evolution of courts martial in order to locate their relevance and effect in our current systems. In this regard, I have considered the era of the Romans. While the Roman Empire is often considered one of the most influential and impactful empires in history, most historians would not consider it to have been the greatest empire in terms of sheer size. However, the Romans are credited with codifying and maintaining accurate records. The Roman Empire's legacy of military discipline is notable for its extreme punishments such as dissemination, where 1 in 10 soldiers were executed for collective disobedience. Collective disobedience included such offenses as mutiny, and mutiny included offenses like tree-sitting, sabotage, among others. Tree-sitting meant that the rank and file of men in the mutiny would choose to sit under a tree and not do any work. Annihilation was the extreme measure historically used to enforce discipline in the rank and file of the Roman army. In the later years, the Normans emerged following the Romans. The Normans, or the Normandy, introduced trial by combat to settle disagreements over money or chattels, movable or immovable, including land. Participants engaged in physical combat until one was killed or 2 wounded to continue. The loser was harmed, reflecting the belief that God had found them guilty. This particular practice of combat was outlawed in the 19th century, with survivors being charged and tried for criminal offenses. One of the Normandy kings, William the Conqueror, developed military justice and influenced feudal traditions in the United Kingdom, including duels and again trial by combat. The duel significantly influenced modern culture. The duel was just like the combat, a situation where 2 persons who had a conflict fought it out physically. The duel in our modern days is the equivalent of the adversarial system in the court, where lawyers for and against parties do battle. The lawyer's sword today in court is his spoken word. It is a duel of words, but it was a duel in the Norman days. The shire courts were introduced by William the Conqueror and maintained by him. These were courts made up of clergy and local leaders who sat and decided cases and received alms from their salaries. That also explains the lawyers' dressing today. It came from the shire courts. Under William the Conqueror, the principle of resolving disputes within the military hierarchy persisted and influenced courts martial. We then go to King Gustavus Adolphus. King Gustavus Adolphus of Sweden formalized military justice with his 167 articles of war, introducing regimental and standing courts martial to enforce discipline and morality. these systems were credited with fairness and morality, and hence influenced both Europe and the British military laws. And up to date, there are military academy known as the Gustavus Academy. The Soviet Union. The Soviet Union discipline of its rank and file was enforced through punishments, awards, incentives, and enhanced patriotic zeal. Severe discipline was demanded by Lenin and Stalin to effectively use modern war implements like tanks and airplanes. The punishments in the Soviet Union included drinking restrictions, surveillance, counter-surveillance, and even physical searches. One of the most notorious infractions a Soviet soldier could commit was drunkenness. The persistent inspection and searches of the soldier military personnel frequently made it difficult to smuggle alcohol into their garrisons and posts. A non-fiction writer identified alcohol as the primary cause of disciplinary infractions in the Soviet armed forces, resulting not only in drunkenness, but also in theft, bribery, report falsification, and deliberate damage. Alcohol was used not only to deaden the senses and allow a period of escape from the hardships and pressures of daily life, but also used to celebrate and commemorate every event. Soviet soldiers and sailors were supposedly only permitted to drink when expressly allowed in accordance with the regulations. The Soviet soldier drank when the opportunity to drink presented itself, in direct violation of disciplinary restrictions. They were so starved of drinking that they resorted to drinking the eau de cologne, eating shoe polish when vodka was unavailable. This infraction, though minor, could lead to severe punishment, including imprisonment or banishment to Siberia. The British military system, originating from the medieval court of the chivalry, involved tribunals. The decline of the court of chivalry led to councils of war, which addressed offenses such as mutiny and desertion. They enacted the Mutiny Act of 1789, which established a legal framework for the courts-martial, ensuring discipline while introducing procedural safeguards. Key issues included the struggle for control over the military justice system and the development of military due processes. The American military justice system originated during the Revolutionary War, drawing heavily from the British military courts. Post-World War II dissatisfaction with the wartime military justice led many Western countries to adopt more judicial approaches and procedures in their military justice. The American military justice has often seen the intervention of the U.S. Supreme Court in military matters. The question of the status of the offender are constantly under review. A status of the offender determination by the courts helps in restricting which offender is liable to appear and be tried before a court-martial. Often, the spouse or dependent of a serving officer and a civilian worker connected to the military either lose or have their day in court when found offending. The cases of Milligan or Callaghan, Kinsler, and Curry are but a few examples of judicial review of military justice. The determination of what amounts to peacetime and wartime offenses are interrogated by the civilian courts. Uganda's military justice system. Uganda's military justice system was influenced by the British military law, partly because we were colonized by that country. Fast forward, the 1975 Economic Crimes Tribunal established by the government of the day between 1971 and 79 was established to punish profiteers, hoarders, and others acting against the state's economic interests, with penalties including death by firing squad or imprisonment. During the period 1971-1979, military tribunals often tried civilians and soldiers alike with little regard for fairness or due process. The system was highly politicized, with military tribunals taking precedence over the civil courts. In its military institutional framework, Uganda borrows heavily from the British, the American, and indeed the Soviet or former Soviet states militaries. We have offices such as the judge advocate and the political commissar, which are vestiges of our non-aligned associations with those countries. I will now move to the matters at hand. Notably, the provisions in Section 119 are at odds with the constitutional guarantees under Chapter 4 and 8 of the Constitution of the Republic of Uganda. The current status of court-martial in Uganda is that all officers who sit on the General Court-Martial are serving army officers who are appointed by the High Command and are men under authority at all times. This means that the setup of the military courts does not follow a process that gives assurances that they will be independent and will deliver justice without fear or favor. By the very nature of their appointment, the structure and the reporting lines, courts-martial are firmly under the superior command and possible instructions of their bosses. Articles 21 and 28 of the Constitution, which provide for equality before the law and a fair trial, offers the following guarantees. The guarantee for equality. Equality means that all persons who appear before a tribunal or court of law are treated equally regardless of their race, their gender, age, or other factors. Presumption of innocence. That an accused is presumed innocent until proven guilty. Burden of proof. The prosecution must prove its case beyond reasonable doubt. An independent and impartial tribunal. The trial must be conducted by an independent and impartial tribunal. Opportunity to present evidence. The accused is granted the opportunity to present evidence and to challenge the prosecution's evidence through cross-examination. Right to an interpreter. That the accused has a right to an interpreter if they cannot understand the language being used in court. Protection from self-incrimination. That the accused has protection from being forced to incriminate themselves. Right to a public hearing. That the trial shall be open to the public. Right to be represented by a lawyer. That the accused has a right to be represented by a lawyer of her choice at all stages of the trial. I have found that the determination of the jurisdiction of the courts-martial attracts investigation of the legislative intent of creating it. And I ask the question, was it the intention of Parliament to vest the courts-martial with jurisdiction to try only serving officers for committing a service offense, or was it their intention to extend military jurisdiction to civilians? Reverting to the long title of the UPDF Act, it is clear that the application of the law was intended to be restrictive rather than general, as it specifically states that it is an act to regulate the Uganda People's Defense Forces. To this end, Section 197 of the UPDF Act also states clearly that there shall be a court-martial for defense forces. How does this stand with the Constitution? Article 44 of the Constitution provides 4 non-derogable rights. The safeguards given under Article 44 include protection from torture, cruel, inhuman, or degrading treatment or punishment. The second is the protection from slavery and servitude. The third is a right to a fair hearing. And finally, an entitlement to a writ of habeas corpus. Essentially, these 4 rights are established as non-derogable, meaning they cannot be taken away even in emergency situations. When juxtaposed against constitutional provisions, sections 2, sections 1191G and H, and section 179, the jurisdiction of the court-martial is properly vested where there is a demonstrable connection and causal link between the service offense alleged to have been committed and the status of the offender as an active duty and image bearer of the armed forces. The status of the accused is pertinent in establishing the jurisdiction of military courts over civilians. It cannot be overstated that courts-martial present a viable means of implementing military justice in a practical, efficient, and flexible manner. We would borrow from other jurisdictions which make a proposition that national defense mandates an armed force whose discipline and readiness are not unnecessarily undermined by the often deliberately cumbersome concepts of civilian jurisprudence. Yet the dictates of individual liberty clearly require a check on military authority in the conduct of court-martial. The provisions of the American Unified Code of Military Justice with respect to court-martial proceedings represent a congressional attempt to accommodate the interests of justice on the one hand with the demands for an efficient and well-disciplined military on the other hand. Indeed, the true test to be directed toward comparing court-martial with contemporary civilian forums is not that we have improved from an epoch that was said to be unjust, but rather that we are comparing favorably with the current constitutional mandate. So when I talk about the historical evolution of the military justice, the idea is not to say that since things got better, but rather to say where do we stand today. The true test ought not to be that military justice today has a semblance of due process. Rather, the test should be whether the military court-martial as it currently is living up to and can be held against the standards that offer protections for individuals against prosecution, detention, without trial, and do not permit any limitation of enjoyment of rights and freedoms beyond what is acceptable or demonstrably justifiable in a free and democratic society. I find that it is constitutional to create and have general court-martials. Historically, the purpose of the general court-martial was to instill and maintain discipline in the rank and file of the armed forces. To the extent that it exists to discipline and bring justice to its own rank and file, who are in conflict with its laws, its processes, and its procedures, the existence of the court-martial cannot be questioned. Let me conclude on this note. Court-martial are specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with the discipline and regulation of the armed forces. The Constituent Assembly, while debating the setup of the Army Corps back in 1992, envisaged military courts as special purpose vehicles to enforce discipline within the military and ensure that there was a battle-ready and disciplined force anytime they were needed. Leading up to the enactment of the 1995 Constitution, the CA did not support granting army jurisdiction over civilians. The Constituent Assembly laid emphasis on the necessity to guarantee a free and fair trial and other due process rights and critical need for the independence of the court-martial, stressing that their role be limited to handling military-specific offenses against military personnel. The General Court-Martial, as currently set up under the UPDF Act, is fundamentally incompatible with the constitutional safeguards for a fair hearing and is unconstitutional, and therefore its exercise of judicial power is equally unconstitutional. To re-echo the words in Curry, the court-martial system structure, including the convening authority's power to prefer charges and select court-martial members and report back to superiors, is fundamentally at odds with the due process and constitutional in the civilian justice system and even unjustified in the military justice system. Having found as above, I hereby make the following declarations. Judicial power in Uganda is exercised by the courts of judicature, and such subordinate courts as Parliament may by law establish. The court-martial system established under Section 197 of the UPDF Act is therefore one such subordinate court. I would declare that Section 197 of the UPDF Act, which establishes the General Court-Martial, is not in breach of the Constitution. However, it is an overreach when the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court-martials for offenses of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171H, 1177 of the UPDA Act unconstitutional. I would set aside the decision of the Constitutional Court in this regard. I find Sections 177 and Sections 1171G of the UPDA Act in its current form unconstitutional for enabling the surreptitious prosecution of civilians in military courts. For clarity, the above sections provide that every person found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces or to other classified stores as prescribed is liable to be prosecuted before a court-martial. I uphold the decision of the Constitutional Court to the effect that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for UPDF members, but lacks jurisdiction to try civilians for offenses under the Penal Code or other enactments. I would declare that the arrest, detention, prosecution before the court-martial of the cross-appellant respondent and civilians of equivalence under Section 1191G, read 1171G, is in breach of Articles 21, 28, and 44 of the Constitution of the Republic of Uganda. For reasons above, I will make the following orders. In their current form, courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of court-martial, save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by court-martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military court-martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by court-martial and have already served their sentences. For efficiency and proportionality purposes, I will invoke the doctrine of prospective annulment on decisions, orders, and sentences of court-martial which have already been served. That notwithstanding, I would order that all cases currently pending trial before the court-martial be suspended forthwith. An injunction, don't issue, restraining the instigation, reopening, or continuance of the respondent's trial before the general court-martial or other court-martial. I join issue with the recommendations or advisory orders proposed by the Honorable the Chief Justice. To these, I would humbly wish to propose a status of the offender determination in civilian courts. When the necessary legislative amendments have occurred, it should be imperative that prior to subjecting a civilian or person considered so by color of right before future court-martial, a status of offender determination be made to the High Court of Uganda. Such investigation should be subject to the highest scrutiny, akin to extradition proceedings or movement of jurisdiction. The courts will have to be satisfied by an explicit demonstration that the interests of justice cannot be served in the ordinary courts of judicature. This standard would be applied to all matters in review. I further would propose to refer the proposals for amendments raised in Second Lieutenant of Van Ambrose versus Uganda, Supreme Court Criminal Appeal number 48 of 2021. The Supreme Court found that the UPDF Act in its current form creates a separate judicial system which has no recourse for appeal or judicial review to superior courts. The court called for legal reform and amendment of the UPDF Act in order to enable the courts of judicature to exercise their mandate of judicial review over the courts-martial. In this regard, an amendment of the Uganda People's Defense Forces is required to confer appellate jurisdiction to the apex courts for them to be able to lawfully entertain appeals from the courts-martial. The other question of one raises is a requirement to delimit what a service offense is during this time. I propose that a soldier who commits a civilian offense when he is off post and away without pass leave or award should be arraigned before the civil courts, civil as opposed to military courts. The cross appeal succeeds, the main appeal succeeds in part. I make no order as to process.
This is a summary of my judgment. Judgment will be provided as the head of the panel will advise. The appeal and cross appeal in this case against the decision dated 1st July 2025, rendered in the Constitutional Court. The quorum of Kakuru, Opura, Drama, Misota, and Kasulu Doctrine judges in the Constitutional Court. That is Michael Kabaziguruka, Honorable, what has agreed with. The Attorney General is the appellant, stroke respondent, and Honorable Kabaziguruka is the respondent, cross appellant, stroke cross appellant. The particulars relating to the declarations and orders stated in the respondent's petition, the issues identified for determination by the Constitutional Court and its decision on those issues, as well as grounds of appeal and those of the cross appeal, have been set out in detail in the judgment of the Honorable Chief Justice, which I've had the opportunity to read the draft. I also had the opportunity to read the draft, the judgment. The judgment from Mogeni, Justice of the Supreme Court. And in the interests of brevity, I'll straight away go into the discussion of the findings in my judgment. However, before giving my views, I should say that when the respondent filed his petition on 17th November 2016, he was challenging certain provisions of the UPDF Act 2005. Under the 2023 revised edition of the laws, where the UPDF Act is now Cap 330, the numbering of many of the impugned provisions has changed, as indicated in the judgment of the Honorable Chief Justice. Nonetheless, in this judgment, I make reference to the numbering of the relevant provisions as set out in the respondent's petition and the judgment of the Constitutional Court. Although for future purposes, the numbering contained in the revised Act should apply. My judgment, and I said I'm giving a brief a summary of it. As I have indicated in my judgment, which you will get, the grounds of appeal and cross appeal, in my view, raise the following questions for this court's determination. Whether the 1995 Constitution places limits on the jurisdiction that Parliament can confer on the General Court-Martial and the other military courts, and if so, what is the scope of those limits? Whether the jurisdiction conferred on the General Court-Martial and other military courts under the UPDF Act goes beyond the applicable constitutional limits. Whether the General Court-Martial is a subordinate court within the meaning of Article 129(1)d. Whether the general courts martial have jurisdiction to conduct the arraignment of the respondent, and if so, whether the arraignment contravened the respondent's rights to a fair trial, whether the general court martial and other regional courts lack the capacity to render a fair trial, which is a non-derogable right guaranteed under Articles 28(1) and 44(c). And lastly, what are the appropriate remedies to grant in this case? My perspective on these questions is as follows. The first question being regarding the limits under the 1995 Constitution on the jurisdiction of the military courts. I find that the military courts are established as military organs of the UPDF under Article 2010A, and that the 1995 Constitution under Article 2010B limits the jurisdiction that Parliament can confer on any military court because the matters fall within the sphere of discipline and removal of members of the UPDF. This implies that the nature of cases that may be tried by the military courts are limited to disciplinary offences committed by members of the UPDF, and the nature of punishment that can be imposed for such offences is limited to the disciplinary sanctions, which are also provided, which are dismissal with disgrace, reduction in rank, forfeiture of seniority, suspension, severe reprimand, and caution. So for the analysis of the first question, you'll find that analysis on pages 2 to 10 of my judgment. Second question, in relation to the second question of whether the jurisdiction conferred on the general court martial and other military courts under the UPDF Act goes beyond any applicable constitutional limits, I find that it does in many respects as follows. First, in respect of Section 2 and Section 119(1)(a) to F of the UPDF Act, which confer jurisdiction on the general court martial and other military courts to try members of the UPDF for offences under Part 6 of the UPDF Act. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, insofar as the punishments prescribed for Part 6 offences are not only limited to discipline sanctions, the only punishments that can be imposed by military courts under 2010, but include serious punishments like the imprisonment and the death sentence. Second, in respect of Section 2 and Section 179, which confers jurisdiction on the general court martial and other military courts to try members of the UPDF for offences under the Penal Code Act and other enactments. The jurisdiction also goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, in that punishments prescribed under the relevant laws are not limited to only disciplinary sanctions. The only punishments that can be imposed by the military courts under Article 2010. And they include serious punishments like imprisonment and death sentence. Thirdly, in relation to Section 2 and Section 1191G, which confer jurisdiction on the